Adam Lally has responded to Karen Reed's defense claims of double jeopardy. You can't try her twice. So her defense attorneys have come out with, hearsay evidence that my friend and my friend and my friend and my friend heard that one of the jurors said they all decided she was not guilty. And there were 4 separate informants. One of them is highly suspect. And, the way that this case has been presented, there's a lot of trolls online pretending to be certain people in the Albert families, Jen McCabe. There's a lot of people trolling this case and trying to push a false narrative. You'd have to approach any juror that's come out of the woodwork with extreme discernment. Lally says the jury did not indicate agreement or acquittal on any of the charges. In their filing, prosecutors say a retrial could not constitute double jeopardy because the jurors did not reach any verdicts, partial or otherwise. And remember that note that they gave to Bev that was so well written? They didn't say, we're hung up on one charge. They said, we cannot reach an agreement on the charges because we have fundamental differences of opinion, right? So prosecutors say the motion filed by Reed's attorneys is premised upon hearsay, conjecture, and legally inappropriate reliance as to the substance of jury deliberations. They argue that Reed was given a full opportunity to be heard throughout jury deliberations, which ended on July 1st when Cannoni declared a mistrial, which is true. They argued about the jury slips and the judge let Al Jackson change the jury slips. Lally and McLaughlin claimed that contact between Reed's attorneys and jurors was impermissible, and that any contact should be reserved to attorneys' performance during trial. Outside influences on jurors' decision or jury bias. What the defendant's motion is entirely premised upon, and what is expressly prohibited inquiry, is that the jury's deliberative process and the substance of the jury's deliberations. It is improper for counsel to inquire with jurors or through intermediaries the individual or collective thought process of the jury. In the same vein, prosecutors say the court should not inquire about the substance of jury deliberations and that polling the jury on the various possible verdicts would be an unwanted and unwise intrusion. Jurors sent notes to Cannoni twice indicating they were at an impasse before the mistrial was declared, and both times Cannoni sent them back to deliberations. It was only after a third note, in which jurors said their perspectives on the evidence were starkly divided, that the mistrial was declared. Those notes were unambiguous, and jurors consistently said their impasse was not due to a lack of understanding of the evidence, but because of fundamental disagreements about its impact, according to prosecutors. Any further consultation with attorneys on next steps in the trial following the third jury note would not have garnered any fruitful alternatives, and there was no reasonable probability jurors would have consented to further deliberations. Each time the jury came back, Reed's attorney, David Iannetti, argued that jurors should be read the Tui Rodriguez instruction, which is commonly done prior to a mistrial. The defense was the one that was pushing it along. Read that note, read the note. So they were pushing for the mistrial. They were pushing towards the mistrial. And now all of a sudden, no, we don't want that. Oh, no. Give me a break. None of Reed's attorneys objected to the mistrial after jurors were dismissed and a date for a status conference was set. And law tubers know this. That would be the time that the attorneys can say, Your Honor, I need to be heard. I object to this mistrial. And, objection would have been noted at least. Even if she didn't agree, even if she was like, I already declared a mistrial, the objection would have been noted. They did not object. So Conspiracy Karen will be back in court on July 22nd. Let's see what new lies she can come up with before then. It's important that a lot of her supporters should actually be acknowledging at some point that everything that they've been told through certain law tubers has been incorrect. It doesn't follow the law. There's no precedent. They are completely lying to back up anything that Karen Reed's attorneys say. Now, you need to question that. I mean, a lot of you probably haven't used your brain since the 1900s, but if you're capable, if there's some electricity running through there, you should start to catch on. I mean, come on now. It's blatantly obvious that they are just doing this for press. Not only that, but I think they're doing it to intimidate the jurors, the guilty jurors, because now they're like, oh shit, I'm going to be called. I'm going to be outed as someone that voted guilty against Karen Reed, who has a mob of the Hills Have Eyes people that attack anyone that disagrees with them. So, I mean, this is like jury tampering, jury intimidation at its finest. So, wakey, wakey.